the jury going to perceive me if I just stand up and keep objecting? They're going to perceive you as a lawyer, right? Objecting doesn't stop you from being perceived as a lawyer. So I would encourage you to go ahead and be that lawyer, because that's the hat that you put on when you walked in the courtroom. It's the hat that you put on when you decided to take this job. It's the hat that you put on when you sat down at that table. Um, we're going to talk about some specific objections during particular parts of the trial, but I would like you to keep in mind to constitutionalize it. I would also like you to keep in mind that objections must be specific. So if you're objecting, there are certain legal arguments that you have to make, but we've reduced them down, right? We have relevance. Objection, Your Honor, it's not relevant. Objection, Your Honor, it's hearsay. Objection, Your Honor, this is an extraneous. Like, we have different ways to pare it down, but we pare it down all the time. So use your legal objections and make sure that those objections are specific. If you're upset because, the question calls for speculation, objection, speculation, but don't be vague with it. Make sure you obtain a ruling. When I was a rookie lawyer, I actually had fun with this. I was in Judge Crocker's court, and I stood up and I made an objection. She didn't rule on it. She seemed a little bit confused, and I just stood there and waited, right? So she gave some response, like, move along, counselor, which, courts love to do. And I was perfectly willing to move along, but not without obtaining a ruling first. So her head was down, and she was doing something else, and there was this lag in the courtroom. It was too silent for too long. So it caused her to look up, and there I was standing there. And, they say children have wide eyes. It's part of the reason you know that they're children. Their eyes are a bit wider, haven't quite set in their face yet. And I was still a young attorney, so I decided to play the rookie card. And I stood there wide-eyed. The moment she looked up, my eyes got wider. And I just sort of shrugged helplessly, and I said, may I have a ruling, Your Honor? So for the young lawyers, Hensley, you got that still. Work it. But other than that, make sure one way or another the judge is making an actual ruling. And now we get to pretrial motions. And this is the beginning part. I said we were going to go through each phase. So we get to pretrial motions, and you've worked this case up. You've done the investigation. You have figured out the evidence that hurts you. You figured out the evidence that helps you or that you don't really too much care about. And you go back to what hurts you and you start taking a look at it. You have to figure out, how am I going to keep this out of evidence? What objections am I going to make? And a lot of times in terms of pretrial motions, we're talking about motions in limine. We're talking about motions to exclude. We're talking about motions to suppress, particularly if it's a drug case or something like that. So each one is a little bit different. Motions in limine are the go-to that most people use. And we use motions in limine because we can kind of foresee that something might just make it into evidence. The problem with the motion in limine is it does not preserve error for appeal. All right, so you can sit there with the motion in limine all day long, but you're not going to have error for appeal later on. It does, however, mean that you have to approach the bench before that particular evidence that you're concerned about comes in. And it gives you the opportunity to have this lag time where you get to say, well, let's take the jury out and let's discuss this a little bit further. Let's have a hearing on whether or not it should come in, or let's proffer the evidence first, since we now have the witness sitting in the witness stand. A motion to exclude does preserve error, but I think it's very important that you still object to trial, because if at the time that evidence is proffered, you just stand on your motion to exclude and you just say, oh, we have no objections, wrong, all right? Now you've waived it for appellate purposes. Arguably, you've waived it for appellate purposes. So make sure you just renew your initial objection in the first place. Uh, with regards to stuff like that, where the judge has ruled on something previously, I like to just put on the record to the judge, as opposed to, you know, getting too deeply involved in this. At trial, I will simply renew my objection. That way it's on the record. You know that I'm actually objecting to all this other stuff, this 2-day long hearing that we had, that sort of situation, as opposed to going back over everything. Motions to suppress. These are the things that we hear about before we become lawyers, where people get off on a technicality, and we want to do that, right? We want to walk out with all these cameras present and just walk somebody on a motion to suppress. But it requires a lot of research. And one thing I'll say about a motion to suppress, I think that we as defense lawyers should be very general in our actual motion to suppress that we file. But you need to have your own little brief that goes into a whole lot more detail, that lists the law that you're standing on, that you're applying, and have all of that stuff briefed. Be ready to distinguish it. If the prosecutor did their homework, you're going to have to make sure that you did yours. Voir dire. So we stand before 65 people in a felony situation at least, and we ask them questions. We listen to the state ask them questions. And there are more objections that you can do in voir dire than the 4 that I've listed. I'm sorry. Anyway. Questions that misstate the law is a biggie, all right? So for instance, prosecutors here in Harris County like to do the one witness rule. And a month ago, we were about to pick a jury on an aggravated sexual assault of a child case. And typically on those kind of cases, you have one witness that the state knows that they can call to prove that up. So here she is, she's talking about the one witness rule, and she leaves out the whole beyond a reasonable doubt part, right? So she's up there saying, well, if you believe the witness as to all the elements, well, that's not the standard, right? So you have to know the law in order to state your objections. That's not the standard. So I objected that she had misstated the law. We then go up to the bench. At the bench, the judge says, well, he wasn't paying attention, so I have to restate it, but I don't know that he would have known it anyway. And so sometimes we have to educate, right? And so I said, well, you know, the state didn't mention that you have to believe that one witness as to each element beyond reasonable doubt, right? So that is the standard. You have to know the standard backwards and forwards. That's part of being prepared. Commitment questions. That's where you ask someone a question that commits them to a particular verdict or a particular way that they must think or act. And then, of course, in terms of challenges for cause, you can have as many of these as you want, but make sure that your wording, I'm sorry.
I was just going to say, the example you gave about the one witness rule, it is technically a misstatement of law. That is correct, but it is also an example of an improper commitment question, because the jury is the prosecutor is seeking to commit the jury to a resolution, because the juror must convict if they believe that the witness beyond a reasonable doubt as to all the elements. They must convict. So if the prosecutor commits them to that, that's fine. But if they leave out the reasonable doubt component, it becomes an improper commitment question. It is okay to ask a commitment question that's a proper one, but it becomes an improper commitment question. But you're absolutely correct that it is a misstatement of the law. But I just wanted to point out that it is also an improper commitment question. It's an example of an improper commitment question.
Thank you. Challenges for cause, of course, we get as many of these as we want. The thing about challenges for cause is you have to watch out for any potential Batson challenges, and people tend to think Batson challenges are difficult. Eric and I have had this happen. There was one Batson challenge that we were granted. It's a three-part process. The first part being that the defendant has to state a prima facie case, right? That something improper happened. So we're in trial on a murder case. The defendant was African American. It was in 2009, March of 2009. The, well, then President-elect Obama had just won election and had just been installed that year in 2009. So a lot of people of color had registered to vote, and somewhere in the midst of that, we ended up with this really high number of African Americans on this panel. After challenges for cause, in the first 18 seats, we had 5 African Americans that were still qualified to sit on the jury. And then beyond that, in the 40s, we had, I think juror number 40 and 41 were both African American. So altogether, there were 7 African Americans, and the state had 10 peremptory challenges. They used 7 of their 10 peremptory challenges to get rid of 100% of the qualified African American jurors. 7 out of 10 to get rid of all of the African Americans. Those numbers are questionable. Those numbers on their own stink to high heaven. So we ended up making a prima facie case. The next thing is, once the defendant has made a prima facie case, the burden shifts to the state to state a race-neutral reason, right? And there are a number of race-neutral reasons. Oops. Let me go back. I object, particularly not being told first. So, appearance, intelligence and educational background, employment, a juror not wishing to serve, health problems, child care concerns, behavior during jury selection, criminal background, including family criminal background, age, community ties, or ties to the defendant's family, political philosophy, prior jury service. There are lots of reasons that are race neutral. But just saying, oh, I don't know, and if they end up stating a reason and their stated reason is, let's say, well, I wanted to get rid of everyone who was over the age of 45, but they have white people over the age of 45 that they didn't strike, stay on it. Keep objecting, Your Honor, that can't possibly be, because we've got juror number 17 who is clearly 61 years of age. Like, stay on it, right? You still have to continue to call their bullshit, because you're looking at it and you're like, that's bullshit. It can't be. 7 out of 10 stinks to high heaven. Yes.
You can ask for the DA's chart to be made part of the appellate record, so if it does go up on appeal, we can also scour it to see if they have any notes or anything.
Does it matter, Janie, if they've made a notation about maybe this person is black, like if they have,
Great.
but what if they did it for white people too?
They did it for Canadians?
Okay, you can tell who's been here for a while.
Can I say something about Fort Iron?
Please. I'm so happy to have appellate here.
What's really important for purposes of appeal is that you say the juror's number. If you can't tell from the record which specific juror is being referenced, we can't do anything with it. Like, if I'm looking at a record and it just says juror, I can stop reading, because I'm not going to be able to explain to the Court of Appeals which particular juror you're So the juror number is really, really important. Some lawyers memorize their names. I think that's not a good idea because if I was on a jury, I wouldn't want you saying my name all the time. But a juror number is, it's critical.
Okay. And I think that's something to make a habit when
Yeah.
you're in trial to refer to jurors by juror number. To make that a habit. And once you start making a habit, you always do it throughout the record.
And also Jamie, like when we were on the 24th floor, so I'm sure you've updated or maybe it's somewhere on the PDO, drive or whatever. But she has a great paper on preserving error in voir dire, and I never go to trial without having that with me. Honestly, so it's in my old email. It's really helpful. You could just resend it.
Okay. So
What happened with that? You made 7 out of 10? What happened?
she granted the Batson challenge, and we ended up coming back to pick a new jury, but we busted that panel. And then after that, we took a reset. Ultimately, the case was tried to an all-white jury. And, they found him not guilty, though. Opening statements. So we get our jury selected, and then we get to opening statements. And I believe that there are always more objections that we can potentially have. But the two main ones that I kind of tend to focus on in opening statements is argumentative statements and improper opinions, because opening statements are generally very short. They're not supposed to be argumentative. You're supposed to tell a story about what you expect the evidence to show. And so I don't harp on the whole, you have to say the phrase, I expect the evidence to show blah, 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 blah. Had one judge who made me do that, and I was very uncomfortable the entire opening statement. But it's, you have to creatively be argumentative. So we have to watch out for it, but we also have to watch out for it when they do it. So if you hear them start off with, in my opinion, object. Or if they say, I think, at the end of this trial, objects. Nobody cares what they think, right? They care. Nobody cares. You can think whatever you want. Personal opinion is not supposed to be a factor in opening statements. Arguing, it's called opening statement because it's not an argument. And so, like I said, we can creatively argue, but that's what we want to do. We don't really want them doing that. Witness examination. So this is the crux of what we do. And so if you hear a leading question, the way a question starts off, unless they're on unless they're doing cross-examination, but most of the time the state's introducing witnesses and we're on direct examination. So they'll say something just by the way the question begins, it's asking for a yes or no answer. You should get up, objection leading. You don't have to wait. Well, you do have to wait for the question to be fully asked, but you don't. Remember, it's about getting in there and objecting prior to the witness, saying anything. So the moment that question ends, you're already on your feet by this point because you knew the way they asked the question was wrong. So you're on your feet. Now you're waiting for them to finish so that you can go ahead and object real quick and get your objection in. So don't let them lead. I think that's important because if you let them lead, they're going to start testifying. And you don't want the prosecutor to testify. It's not their story to tell. And most witnesses are lay witnesses, so they'll just agree with everything, right? We all know about the dog with the newspaper, right? You just keep beating them over the head until they agree, and next thing you know, you're walking them down the path of the story you want to tell. And what we're trying to find is the truth. So the prosecutor was there. Prosecutor doesn't know anything. Don't let the prosecutor testify by leading a witness on direct examination. Lack of personal knowledge. I like this one a whole lot, and yet I think courts let in a lot of it. It's basically speculation, right? Because if you don't have personal knowledge, you're guessing about what happened, right? So someone has asked a question and, they weren't there. They can't possibly say what happened. And what's happening here is Judges are allowing them by saying, well, if you know, you can answer, right? That's what's beginning to happen. So when I say constitutionalize your argument, objection, Your Honor, lack of personal knowledge, speculation, violates the defendant's right to confront. So you put all that together, mash it together, because now when that person now, well, they can say it if they know. Now it's a constitutional argument that they're really, speaking to something that somebody else said, and no one has the ability to cross-examine that other person. Or they're guessing, and all you can do is come back and say, you really didn't know that, right? So your cross-examination is going to fall flat in that situation. Relevancy. There are a lot of things that are not relevant. As a matter of fact, victim impact statements, unless it's closing argument, it's not relevant. I mean, unless it's the sentencing portion of trial, it's not relevant. So that goes with that one. But the reason why is because what the focus is supposed to be on is whatever the elements are and what goes to prove those elements. Anything outside of that, it's rarely relevant. And it's probably going into something else like character or something like that the jury's not supposed to be able to consider. If you fail to object to it, they will be able to consider it for all purposes. We've talked about speculation because it's just someone guessing. Hearsay. Hearsay is a major one, right? Hearsay is all about not letting in what somebody else said, right? So if I know something because Natalie told me, well, we don't know that Natalie is trustworthy, so I don't get to say what Natalie said. As a matter of fact, I'm pretty certain Natalie's not trustworthy. So, but the jury won't be able to see her demeanor or know what her character is like. So the jury will never get the benefit of that. But if I'm more credible than Natalie, then my credibility will then apply to her. So watch out for hearsay. There are some things that are exceptions to the hearsay rule: present sense impression, excited utterance, then existing mental, emotional, or physical condition, medical diagnosis or treatment. So medical records tend to be able to come in if they're properly authenticated. Records of vital statistics. I think we overlooked this one a lot. I think a lot of times just to prove age, the state could just get a birth certificate and keep going. A statement against interest. I'm sorry, y'all. That one hurts us the most. Our clients talking when they shouldn't be. But that's not hearsay. We're always looking for a reason to take their statements out of the equation, but that doesn't happen a whole lot. Asked and answered. If the state keeps harping on the same thing, did he stick his penis inside your vagina? Well, we already heard that. Why are we hearing that again? Why do we have to hear that same thing 50 million times, right? They're doing it for effect. They're doing it because that's what they want to stick in the jury's mind. And they're emphasizing it. It's like putting italics on it. And you don't get to do that, right? It goes against the weight of the evidence. The jury gets to decide what weight to put on evidence. So by constantly going back to the same thing over and over again, they're saying this is really important. They're highlighting it for the jury. So that's the reason why we don't want that to happen. I mentioned in regards to documents, particularly medical records, that sometimes they lack the proper predicate. An example of this is I was in trial earlier this year, and the state wanted to get in a fingerprint sheet from a particular offense that was in a different state. I believe it was Ohio. And so they were last minute getting the sheets, but they got the fingerprint sheet and they got a business records affidavit to go along with that fingerprint sheet. So they had the judgment, they just didn't have the fingerprint sheet, and they thought it would come combined. When it didn't, they didn't look for it, and so here we are in trial. Now they're trying to get the fingerprint sheet. And they end up getting it literally the last day of trial. And they come and show it to me. And they're very, we're going to get this in, blah, 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 blah. Well, guess what? It hasn't been on file for 14 days, right? You don't have the proper predicate. So then she was truly a genius. She calls the custodian of records in Harris County to come and testify about the business records affidavit for Ohio. Yeah, no, we objects. And so she works through this whole entire thing, and be very careful, y'all, because you don't want the jury to hear from this person before something gets entered, and that way they know what it was the state was trying to get in. Keep the jury out of this. Send them to the back. Ask that they be sent to the back. So we had a hearing on this where I said, well, Judge, I'm going to be objecting to this. So before the jury comes in, can we make a determination as to whether or not it's going to come in? So the state says, that's fine, we can go, we can have this hearing in advance. So we do, we have the hearing. And in the hearing, she goes through the whole foundation list, because they've got their scripts. They're scripted, they're very scripted. So she doesn't miss a beat, she does everything she's supposed to do. And then I stand up and I say, are you the custodian of records for Ohio? No. Are you verifying that these records are accurate and true? No, I can't do that. He was saying he can't do that he didn't have the authority to do that, right? So yeah, he can verify Harris County records all day long. He couldn't do that for Ohio's records. So make sure that you're holding them to that standard. Call bullshit. That's bullshit, right? You bring in somebody from Ohio to testify about, from Harris County to testify about Ohio records? That's bullshit. You see it, you know it, you laughed the moment I told you the story. Call bullshit. If someone is assuming a fact, not an evidence, so what that means is they've jumped the gun, right? No one's testified, or that person hasn't testified, that they ever saw Genesis get out of the car, but they've somehow managed to jump Genesis out of the car, and they just presume that she got out. No, let's back up. Did she get out of the car? Where was she? What did she do next? Go back a little bit. I'm very wary about narrative answers, narrative responses. The problem with narrative responses is you don't know where that witness is going to go. So we listen to questions. I've said the beginning of the question tells us whether or not we're going to object. It tells us whether or not we're going to object. And so in the midst of that, if someone just goes on a narrative, you don't know where they're going. They have no direction, and you don't know, are they about to say something objectionable before I have an opportunity to object? So that's the problem with the narrative. And sometimes judges will let them go on a little rant for a while, but make sure you stand back up and object again to the narrative. Don't just let them keep going. In situations where I want to constitutionalize an argument, but I don't really know what the constitutional argument would be, I do what most defense lawyers do. Due process, Your Honor, right? It's just yell out due process, right? I object, this is narrative, and it violates due process, right? So just keep objecting. Find something. That didn't work. You sit down, they're still talking. Get back up and find something else to object about. Objecting is fun. It really is. An improper opinion by a layperson. So lay people are not allowed to give opinion testimony except in very narrow circumstances. They can judge how fast a car is going, for instance, but they don't get to say that in their experience, kids don't lie about sexual things. You're not an expert, so you just hush and keep your opinion. Nobody cares about your opinion, right? So we're back to not caring about somebody's opinion. So be real careful about who's giving an opinion. If they're not an expert, they're not giving an opinion. If they are an expert, but they're not an expert on that subject matter, don't let them give an opinion. So if you have some person who was listed as an officer and they have experience and training and being an officer and patrolling the streets, and all of a sudden they want to talk about kids don't lie. Pause. Are you a psychologist? No. You don't know what kids do. You haven't studied kids, have you? Well, I've been around them. All of us have. And yet, you're not a psychologist. Stick right there to it. And victim impact statements, I've already said they're not relevant, except in sentencing. So, you know, the problem with victim impact statements, they don't go to prove a single solitary element of the offense. They go to say afterwards, I was impacted because I no longer have my mom in my life. My dad can't walk me down the aisle. But none of that is probative as to whether or not the defendant committed a particular crime. So don't go into that. I have objected to victim impact, but you can also just say, I object, it's not relevant. So that gets us through a lot of witness testimony, and then we have jury charges. So this is complicated, and I'm going to tell y'all. I normally go to Sherry Duncan, and I say, Sherry, can you please take a look at my jury charge? There are certain things that she always has in a jury charge. So reasonable doubt is not to be defined for the jury. We tell them this at the beginning. We tell them this in voir dire. You get to define reasonable doubt. There is a portion in the jury charge where the where the judge will tell them what reasonable doubt is not, right? Reasonable doubt is not all doubt. It's not beyond all doubt, some language to that effect. But by telling them what reasonable doubt is not, you're telling them to think a particular way, right? So you are defining it by saying what it's not. It's a negative definition, but there's still some connection there. I object to this. I have yet to win that argument, and I haven't seen it brought up at the appellate court yet, but we're going to keep trying. The sole duty instruction violates the defendant's rights to due process and due course of law because it requires the jury to determine guilt or innocence. When they go to that jury deliberation room, it's not about guilt or innocence. That's not what they're deciding. What they're deciding is whether or not the state proved each element beyond a reasonable doubt. Their sole duty isn't to determine guilt or innocence. Their sole duty is to decide whether the state proved the case beyond a reasonable doubt as to each element. So I object to this. Judge Hill will give us this, right? So it's not like it's an improper argument. It's not like it's a crazy argument. I'm not asking you to go in there and do something crazy. So all judges aren't quite there yet. Hopefully we'll get them there, but we'll keep working on that. Right there in that same your sole duty is at this time. Your sole duty at this time. That language at this time is improper because it suggests that a punishment hearing will follow, which is a comment on the weight of the evidence, right? So what we really want, how we really want the sentence to read is, your sole duty is to determine if each element has been proved beyond a reasonable doubt. That's how we really want that sentence to read, something along those lines. But cut those two things out. Object to any non-statutory definitions. If they define something that's not defined in the code, bring it out. You know, everything that the penal code defines, if it's relevant, can be defined in the jury charge. But if they just want to make up a definition, don't let them do it. Object to a lesser you don't want in the charge, or the failure to get a lesser if you are trying to get a lesser included. So be very careful about lesser includeds. And, you know, always look for that because there's a lot of cases coming back on jury charge error. So don't worry so much about whether or not you get it. Just make sure you're objecting and asking for it. Object to an omission of application paragraph or application paragraph that does not apply the mens rea correctly to the elements of the offense. So that whole knowingly is different. And Sherry has this some offenses are result oriented, and they like to confuse the result oriented crime. Huh? No, I'm messing it up. They're confused. Eric, you know what I'm trying to say. You gonna help me?
You're saying that sometimes they miss that some offenses are result oriented. Instruction is not requiring a result. In other words, the defendant has to have the intent not just to do the act, but intend the result.
Yes.
Those are what we consider result oriented offenses.
Right.
What you're saying? But
Yes.
sometimes they don't include that in the instruction. And the mens rea has to actually also apply to the result.
Right. So murder, you have to intend murder, right? If it's an accident, that's a different charge. It's manslaughter. Object to laundry list. A lot of times when we're dealing with extraneous, is if you were properly objecting during the evidence portion, they got to an extraneous and you were like, well, I object to this, it's an extraneous offense. Okay, well, why are they bringing it in? And there are lots of reasons under the rules that it can come in, but the state probably has one reason as to why it's coming in, to prove motive, right? Or to prove identity, to prove that it's not a mistake. Like, there are different reasons that it can come in. But in those instances, if you get that at the very beginning where the state has to state what its reason is, then make sure that the jury charge pairs up as well. So they put the laundry list in there. You want to take that laundry list out and say, if it helps you to prove identity, then you can consider these other acts to prove modus operandi. And finally, we get to closing arguments. And just make sure in closing arguments that the state's not referencing even casually or subtly that the defendant failed to testify. So if you hear something along the lines of, well, we can't possibly know what the defendant was thinking, and that's a comment on the defendant's failure to testify. Because the only way we could possibly know that is if they testified. So be very careful about those subtleties. Striking the defendant over the shoulder of defense counsel. I gotta say, if the state is picking on me, I kind of think I won, right? Because you're not paying too much attention to the facts of the case. I've had that be my whole entire objective, right? Like, if they're saying bad things about me, then at least they're not saying bad things about my client, right? Sometimes that's the best thing we got. But, so if they're saying, the defense lawyer is ludicrous, you're striking the defendant over over the shoulder of defense counsel. We're the ones that come up with the defenses, and you can think it's ludicrous. That's fine, but that doesn't really do anything towards the argument. Now, they can attack the actual elements. They can say, if what the defense wants you to believe is that this person came in and lied, and that person came in and lied, and that's a different argument, right? And they can build up to it being absurd. But just to say, I'm crazy, we already knew that. It doesn't matter. Personal opinion in closing arguments, still watch out for this. I believe, nobody cares. Nobody cares. You're the prosecutor. Nobody cares what you think. Nobody cares what you believe. But the problem with it is, what if they do care? What if the jury has come to really, really like the prosecutor? And what if that prosecutor feeling a particular way just gets adopted to that one juror, and that one juror is the loudest one in the bunch? No. We're not going to talk about what you think or what you believe. Stick to the actual evidence. Misstating facts, that happens a lot. You've gone through 3 or 4 days of trial, and all of a sudden, everything is all jumbled up, but not to you and not to the state. And the state will just try to leap over a few things and be like, that's not what that person said. It confuses the issues. It confuses the jury, right? So you have to really pay attention and know, no, this person said this, this person said that. Misstating applicable law. right? So I think on murder cases, for instance, you have to really be careful about uh, well, the reasonableness of the defendant's mind state if he's raising a self-defense argument. That's, the one time that you get to say, is the defendant reasonable? Standing in his shoes, is he reasonable? Other than that, you don't get to say that too much. So don't let them misstate the law because maybe they've never tried a murder case and they don't realize that that's an exception. And of course, there are some things there's just an improper argument. If you're sitting there and you think, I think this sounds wrong, but I don't really know why, go with improper argument, right? Just throw it out there. See what happens. Part of being a defense attorney, that is the end. So, okay, questions?
Two things. One, with striking the defendant under the shoulder of counsel, one way you might see it might be a situation where, the common way you see it is where a prosecutor comes in and says, they're arguing that this was reasonable doubt. You hear the prosecutor coming in and arguing reasonable doubt in this situation, and he's pointing to this component. That's just some slick lawyering. That's all that is, slick lawyering. There's no reasonable doubt. It's just slick lawyering. You might see something like that. You might even see it come down to like a factual issue that they're saying is reasonable doubt because they're saying he acted in self-defense, and he's coming in, he's trying to argue that he's reasonable in his standpoint, in his shoes. You put him in his shoes. But when you think about it, ladies and gentlemen, all we've really seen is just some slick cross-examination. Whenever there's that situation, the dig at the prosecutor, the dig by the prosecutor at the defense lawyer, I think you can make the objection that that's striking the defendant over the shoulder of counsel. Sophisticated prosecutors will try to make it seem like it's a factual argument. Just take a dig at the defense lawyer down there. That's all.
You said two things. That was one.
Oh. What about like if somebody used the lion video? A video of a lion trying to get to a kid or something. Would you object to that kind of thing?
Yeah, I think I would. I think so. I think so.
Tell us more.
Huh? So there was a situation, it's State versus Damon Milton, and it's before I think the first Court of Appeals. And it just recently got heard, but it wasn't necessary for the state to go that far, but what they did was they pulled out a video of a lion that was like it was at a zoo, and it was behind unbreakable glass. And in front of that lion was a baby that was sitting there just as oblivious, right? It was a cute little baby. I want to say about 6 months old. But it's sitting there in front of the lion with its back to the lion because somebody wanted to take a picture that turned into a video. The lion is just like trying to break this glass to get to the baby, right? I mean, just trying to get out, trying to break the glass, just wants to get to the baby. And the prosecutor finds this online, and he decides that he wants to play this to the jury. And I object. I mean, I'm objecting for lots of different reasons, but mainly because it's not relevant. And it has the ability to prejudice the jury. I mean, you're looking at this vicious animal and this helpless, cute little baby. And when it comes to babies and dogs, it was a robbery case. I wanted to say it was an aggravated robbery, but there was no gun. It was it was a robbery case. This video had absolutely nothing to do with anything, but it wasn't in evidence. He had some. They wanted to use it as demonstrative evidence of. Well, and so I objected, and I said, he's going to try to make my client equivalent to the lion and say that my client is vicious. Now, mind you, this is a robbery. He didn't even it's not even aggravated, right? Nobody got hurt. A gun wasn't used, so it's not, you didn't have aggravating factors. so, so that was the whole entire thing. He wanted to say, if you don't lock him up, if you don't send him away in a way that's meaningful, he's going to get out and he's going to harm society, right? The only thing protecting this baby is this glass. It's the fact that it can't get past this glass. And so you have things like that. And he was trying to be creative and think outside of the box, but anytime they start getting creative, like we know what they normally do, anytime, and we're ready on those objections, but anytime they go off script and they start like doing something weird, it's like, I've never seen this before. Start objecting, just objects, object. Oh.
Appeal to PDR. They filed a PDR, and I think it was argued to the Court of Criminal Appeals, and it's awaiting of opinion from the Court of Criminal Appeals.
Okay. It was a visiting judge. It wasn't, I don't remember.
Well, does anybody have any questions for Jackie? Thank you, Jackie.
Thank you.
I have one question, last question. Can we get your PowerPoint? Would you have a problem emailing it to me?
all this stuff in.
That's why I would take notes. I was going to ask for the PowerPoint.
I'll post it on the J Drive. Or I can email it. Which one is better? You can't get past the lion?
Stuff.
You have one more presentation?
You want me to get that?
Okay, so we had Ted Wood.
See, now it's all sweaty.
Jay, you want to introduce that?
Thank you.
Ted Wood is gonna talk to you about court costs, something that's very, close to his heart, is saving our clients from paying a lot of money, and he worked very hard on this bill in the past that now provides relief to our clients. And so he's gonna talk to you about that and the things that he's done, and for those who don't know, he's a former county judge, and he worked at the Office of Court Administration for many years, training judges. So he's pretty good, and, he's a very nice man.
Thank you. All right, thanks for that introduction. Let me first say to this audience here that this presentation is being taped by the Texas Criminal Defense Lawyers Association. They're going to make a little video for the members of TCDLA on this topic. So while I'm talking live to members of the Harris County Public Defender's Office, I'm also talking to a broader audience statewide of defense attorneys. So if some of the things I say seem to be not directed exactly at everyone in this room, that's why. Again, my name is Ted Wood. My job with the Harris County Public Defender's Office is to be a legislative liaison between our office and the state legislature. And so I spend a lot of time looking at bills that are filed, offering testimony on ones that we support, offering testimony on ones that we don't support. And we've had some luck in getting some good things passed and actually in getting some things stopped that were detrimental to us. So that's my job. And besides drafting language that might become law and testifying on bills and that sort of thing, it's part of my job to try and come back and tell you what has happened in the legislature, and so that we can go forward and use some of that. And that's my purpose today. I have a handout that I've given to everyone, and the reason I didn't do a PowerPoint is that this is quite intensive in looking at the language of the statute and at a particular motion, and so I want you to have that. Everyone in this room has it, and those of you who are watching this video, you should have an accompanying 14 or 15 page handout that you're not going to get anything out of this presentation without the handout. So please have that at the ready so we can look at it. What I'm going to talk about today are two bills that cover the same territory. One is Senate Bill 1913, the other is House Bill 351. These were both passed in the 85th legislative session, which occurred in the spring of 2017. And the law went into effect on September 1st, 2017. Well, today is December 11th, 2018. So we're 15 months past this, and we really haven't taken advantage of the law that has been passed. So that's why I want to get the word out to the Public Defender's Office here in Harris County. That's why we want to get the word out statewide to what happened. First of all, Senate Bill 1913 was sponsored by Senator Judith Zaffirini of Laredo. House Bill 351 was authored by Representative Terry Canales of the Valley. And both bills started in different places. House Bill 351 was a very short bill. Senate Bill 1913 was a very long bill. And during the legislative process, Senate Bill 1913 became a little bit shorter. House Bill 351 became a little bit longer, and they ended up in the same place. But what they ended up doing was putting into effect a policy that the Texas Judicial Council wanted to see happen. And for those of you that are not familiar with the Texas Judicial Council, it's the policy-making arm of the state judicial branch. And it's made up of about 20 individuals. A lot of them are judges, and the lead member is Chief Justice Nathan Hecht of the Texas Supreme Court. And he has been extremely supportive of efforts to try and keep people from being put into jail or serving time simply because they can't pay their fines or their court costs. And he's the lead member of the Judicial Council, and so this was an initiative that the Judicial Council supported, and it took the shape of these two bills. So now I want to get to the specifics of the bills, and what I mentioned on the very first page is that we could talk about a lot of different aspects of Senate Bill 1913, and I'll just refer to both bills as Senate Bill 1913 because they are essentially the same. But they put into place a provision in the Code of Criminal Procedure, which I have highlighted there on the first page. It's Article 42.15, and specifically subsection A1 of the Code of Criminal Procedure. So if you'll turn with me to the second page, I have set out subsection A1, and I know this seems dry, but what I want to do is just read through this statute word for word, and it takes the upper half of this second page. I've tried to highlight what I think are the key parts. So let's read this. It says, notwithstanding any other provision of this article, during or immediately after imposing a sentence in a case in which a defendant entered a plea in open court as provided by Article 27.13, 27.14a, or 27.16a, a court shall inquire whether the defendant has sufficient resources or income to immediately pay all or part of the fine and costs. Let's just stop there. Okay, let's look at these key things. During or immediately after imposing a sentence. That means when the person pleads guilty or when the person has been found guilty after the sentencing phase. Right then, at that point, there is supposed to be a determination made by the judge as to whether this person can afford to pay the fine that's been assessed and whether the person can afford to pay the court costs that are assessed. And in a lot of cases, you're not going to even have a fine assessed. Sometimes you will, sometimes you won't. But you will always, in any conviction, and even in situations where there's an order of deferred adjudication, you will always have court costs assessed because it's automatic. The statutes say that upon conviction, this court cost here shall be assessed. This one over here shall be assessed. Typically, in a felony case, that's going to add up to $450, $500. In a misdemeanor case, a lot of times it's more in the $250, $300 range. But those court costs are going to be assessed. Now, notwithstanding the fact that they've been assessed, what this statute says is right then, a court shall inquire. So this is not something that you need to beg and plead for the court to do. They're supposed to do this on their own. That doesn't mean it's happening. My understanding on talking to you is that this never happens in Harris County. And I don't think this happens in most places in the state of Texas. I'm not saying it doesn't happen in some places. But for whatever reason, judges either are not aware of this or they're not following it. And so what I'm suggesting to all of us is that we need to prompt the judges. We need to let the judges know that this is their duty to make this finding. So let's go on. They need to inquire whether the defendant has sufficient resources or income to immediately pay all or part of the fines and costs. In other words, can you pay it today? Immediately means today, not a month from now, not 6 months from now, today. Can they pay it today? All right, so that's the first thing that they need to determine. Let's go on with the statute. If the court determines that the defendant does not have sufficient resources or income to immediately pay all or part of the fine and costs, the court shall determine whether the fine and costs should be, and then there are 4 choices. Okay, number 1, required to be paid at some later date. So it is okay for the judge to find, look, you can't pay it today, but based on your circumstances, I think you can pay a monthly amount and pay this off over a year or what have you. That's acceptable. That's an acceptable finding. Another one, discharged, this is number 2, discharged by performing community service. Okay? And that's something that we're going to look for a lot of times. In lieu of having that person on the hook for the fine and the court costs, they can be ordered to perform community service. The third one is the judge has the option to waive, in full or in part, the assessed fine and the court costs. And finally, the fourth one is some combination of those first 3 options. So, this is a new thing for judges. They're not used to it. And in Harris County, at least, we have a great opportunity because we have a lot of new judges that are going to take the bench in 3 weeks. We still have some judges from before, and in other parts of the state, certainly there are going to be some new judges, but you're going to be working with a lot of existing judges. And so, to some extent, this is going to be teaching old judges some new things. But to a large extent, and especially in Harris County, we have a great opportunity to, right from the very beginning, let these new judges know that this is a responsibility that they have to make this inquiry. And to the extent that they doubt what you're saying, or they just can't quite believe it, we have some bench cards that have been put together by the Texas Office of Court Administration. And this is an entity that I used to work for in Austin before I came here to work for the Harris County Public Defender's Office. And their job, in part, excuse me, is to educate judges on certain things. All right? And so they have a bench card. There's actually 2 bench cards. The first one, and it will take 2 pages here. If you look on the third, this should be the 3rd page of your handout. It's called Bench Card for Judicial Processes Relating to the Collection of Fines and Costs. And then under that it says District and County Court Version applies to jailable offenses. So whether you are in the Felony Trial Division here at the Harris County Public Defender's Office or whether you're in misdemeanor mental health, this is the bench card that is going to be applicable to your cases. And I want you to look right about halfway down on this first sheet. It says new requirement for assessing ability to pay during or immediately after sentencing. It cites Article 42.15, and the very first sentence is exactly what I've been saying here. We want to get this across to the judges. At the sentencing of a defendant who enters a plea in open court, and this could be a plea of guilty, a plea of no contest, a plea of guilty, or a plea of not guilty, I'm sorry. At the sentencing, when imposing a fine and cost, the judge is required to inquire whether the defendant has sufficient resources or income to immediately pay all or part of the fine and costs, and then it lists the different options that the judge has. Okay? So if they're not going to take your word for it, okay, pull this out from the Office of Court Administration. I've given you the website address where you can get it, or you can just copy this off. And let them know that the Office of Court Administration has put this out there so that judges are aware that this is what happens. Following this, this will be on the 4th and 5th pages in. There's a separate bench card for justice and municipal courts. And I'm aware that those of you here in the Harris County Public Defender's Office are not working in the justice and municipal courts, but a lot of you who are maybe watching this video do practice in those courts. That's where the punishment is only a fine, and there are court costs assessed there, just like there are in the other trial courts. Things are slightly different here. I won't go into the details, but here's the bench card, and it's especially tailored to the justice and municipal courts. If you get past these bench cards on the handout, I've got a paragraph here on what's denominated as page 7, and I go through what I've already told you, that judges should make this evaluation without being prompted. Our judges this week, our new judges, are at New Judges School in Austin. I have no idea if this is on the agenda, if this is something that they learn about or not. Maybe it is, maybe it's not. I hope it is. But I have a feeling that maybe it's not. And so while we should be able to have the judges sua sponte, on their own, do things that they're required to do under the law, we need to nudge them along a little bit and make sure they're doing it. Now, you should be able to do this orally, frankly, but I'm not sure that that's going to work right away. I think over time that judges are just going to automatically do this and make the evaluation. They'll get used to it. But what I've put together here for you are a couple of motions. The first one is designed to be used in district court in felony cases. And it's a motion for the court to make an ability to pay inquiry. And in the first paragraph of this motion, I talk about Article 42.15, subsection A1, and specifically quote the language that the judge shall inquire whether the defendant has sufficient resources to immediately pay. The second paragraph reminds the judge that at the outset of this case, you found my client to be indigent, and counsel was appointed to represent the client. Now again, that makes sense for all of us here in the Public Defender's Office, where the only clients we represent are indigent clients, every last one of them. But this applies not only to public defenders, but also to attorneys in private practice who have been appointed on cases. They would not have been appointed if the person was not found indigent. Where this probably doesn't apply, or at least doesn't apply so much, is if you're an attorney and you're being paid by the defendant to represent him or her. Then, most likely the judge is going to find that this person does have the ability to immediately pay. Maybe not always, but most of the time. However, for those of us in the Public Defender's Office, those of us who are representing indigent clients in private practice, this should be almost a no-brainer for the judge, because just a few days ago or a few weeks ago, this defendant was found to be indigent, and now, as we say in this paragraph, nothing much has changed. There could be the rare situation where something has changed, but typically not. And so we are, the last line, accordingly, the defendant requests that this court, in this case, waive the assessed fine and cost. That's one of the options, but this is something that I talked about with our director here, the public defender Alex Bunnan here in Harris County, and what he and I talked about was, look, if you have a person who's been convicted of a felony, a lot of times, chances are, they're going to prison, and they're not going to be able to perform community service in prison, and they're not going to be able to pay this out over time. And so it only makes sense that we should ask that the fines and the fees be waived. On the next page, we have an order, a proposed order that the judge can sign. And we really only put two boxes there. One is that the fine and costs assessed against the defendant be waived. And the other one is if the judge finds otherwise, he or she can check the box that says, well, I find the defendant has sufficient resources to pay. But again, most of the time, the facts are going to be such that this person can't pay. Okay, if you turn the page to the next motion, this is designed for county courts at law, or in other parts of the state where the constitutional county courts are hearing these cases. This is designed for misdemeanor cases. And we go through the first paragraph again, talking about kind of the basis for the law. And then we give some options for the judge here. One of them is to order the defendant to perform community service in lieu of making these payments. The other one is just to outright waive it. And there is a statute that talks about how judges should assess community service before they outright waive the costs. So that may happen to your clients, especially your misdemeanor clients, but I want to have you think about something here, those of you that represent clients here on misdemeanor cases. A lot of them may have a physical reason why they cannot perform community service, or maybe it's an emotional or mental reason that they cannot perform community service. So this would be a good time to explain to the judge that not only can my client not afford to pay this, but my client is in no shape, for whatever reason, to perform community service, and we ask that you just outright waive the fine and the costs. This is almost a bird's nest on the ground. I don't know how else to say it. It's a very favorable law that has been put in place by our legislature, and really all we need to do is make the judges aware of it and pursue it. There's an order that goes along with this, and it's kind of what I talked about. There's a couple more options on there simply because the people aren't going to prison. And then the final 2 pages, I won't get into this, but this is an explanation of the motion to the court to make the ability to pay inquiry. So you can read that at your leisure. It's 2 pages of a little more detail. That's all I have. I'm glad to answer any questions that you might have.
I have a question.
Yes?
The determination of a person's ability to pay, is there any guidelines on that, or is that completely subjective?
Well, that is subjective. And it is possible that a person could have been appointed, a court-appointed attorney, because they could not afford to pay whatever that lump sum was to get this going, and still have a job, and still have the ability to perhaps pay, especially over time. Even if they can't come up with the, let's say, $500 fine and another $500 in court costs. That's possible. And so some judges will take the position that, all right, you can't pay it all today. We're going to put you on a payment plan. Can you afford to do this? I expect that some judges may want to do that. I still think that we ought to try and argue that these court costs be outright waived, or short of that, that at least the person be allowed to perform community service. But to answer your question, there is no statutory, there is no statute out there that addresses this particular amount of money is not enough to pay. It's going to be on the basis of what the judges think, and a lot of what the judges think are going to be on how we approach it and argue our client's particular circumstance. Natalie.
How can we use this? I'm just thinking, I sometimes have MAJs where a lot of judges don't violate based on cost, but eventually we whittle away if there are other reasons for violating. They're deferred, and we get down to costs, and they haven't paid their costs. You know, the state always says, but this was supposed to have been happening from September of last year. So is there a way for us to like retroactively use it in MAJ hearings?
Okay. I think that's a good argument to say, Judge, although we didn't have you waive these costs up front back 6 months ago, the law was in place then and we really should have done it. But my client could not afford to pay this, and this was why he or she did not make the payments, not because they disrespected the court, not because they didn't want to. They wanted to, but they couldn't do it. And so we ask that you don't adjudicate them for this reason. My experience has been that while there are a lot of cases where one of the reasons for adjudicating a person who'd been placed on deferred adjudication is that they didn't pay their court costs, that when all the other reasons shake out, courts, even before this, were reluctant to adjudicate somebody or to revoke somebody's probation solely on the basis of cost. So I would make the argument. And
It's constitutional Supreme Court case law that says you can't imprison someone because they can't pay. There's that too, Bearden and Tate.
right, and that's listed right at the top of your
And it
of your bench card. The U.S. Supreme Court has held that courts may not incarcerate a person for non-payment of fines and costs. There it is.
So it's,
Most judges know that. Most judges won't violate based on
I
that.
feel,
Yeah.
and I ran into, I don't remember what court it was the other day, but it was also, the state was pushing it as, because their case started getting weaker on their MAJ, and they started saying, like, using that as for why they're, when we were trying to work it out. It was for costs.
So you may want to educate on
It was
that.
basically. And I guess my other question is, so I think you said this, but it is the judge's duty to do this, even if we don't file a motion or whatever, the judge needs to be doing it.
Yes, that's what's supposed to happen. Eric?
So what if we requested and the judge refused?
Well, I think that would certainly be a great point for appeal, or a motion for new trial maybe. There would be ways to try and attack that, but yes.
So if we did it and we filed a notice of appeal and the judge says, okay, I'm going to give your client an appeal bond, you file them, the routine, right? And the client's like, I don't want to do an appeal bond, I don't want to do an appeal. So we're kind of in a catch-22. Is there any other way to enforce it other than like filing a notice of appeal? I mean, maybe a motion for new trial might be a better route, but.
Well, those are the two routes that come to mind, and let me give that some thought, Eric. Okay, yeah, there is a statute in the Code of Criminal Procedure. It's 103.008, I think. And it talks about, within a year after the judgment, making a motion to correct costs. And that may be a way. You make it in the trial court. So that may be a way to do it, too. I am hopeful, though, that we won't meet resistance on this, that this is spelled out clearly by the legislature, spelled out by the Office of Court Administration. Let me say one more thing about Chief Justice Nathan Hecht. As the Chief Justice of the Supreme Court of Texas, he goes to a lot of conferences around the country that it's a meeting of the Chief Justices of the various Supreme Courts in the country. And what happened in Ferguson, Missouri has been a huge topic of discussion, and somewhat underlying the problems there are that people were being jailed in Ferguson for non-payment of fines. And this is, again, contrary to U.S. Supreme Court law, and it's been a huge topic of discussion among the Chief Justices. And so Chief Justice Hecht has, to the extent he didn't already think about this stuff, he thinks about it a lot now, and he's the lead person on the Judicial Council. And when the Judicial Council gets behind a legislative proposal, they usually pass. And they're usually carried by an influential senator. In fact, we have a couple senators and a couple representatives who are on the Judicial Council. Senator Zaffarini is one of those. So she listened to this, she considered it, she was eager to file Senate Bill 1913 and get it passed. In fact, there were a lot of parts of that didn't make it all the way through the legislative process. It was more ambitious than it even ended up being. But there is and leading judges in this state to see that this happens. It's unfortunate that there's sometimes a little lag time between the law actually becoming effective and me doing my job and getting the word out to you that, hey, this law is passed. In fact, that's why I put it as a news flash. That's kind of being a little funny because it's not like this happened this morning. This happened 15 months ago, but hey, I think maybe some of you are hearing about it for the first time. Jane.
From a practical perspective about making the judges aware of the process,
Yes.
and I'm not trying to be funny, but can't the Office of Court Administration 1 just like mail these to the judges or somehow disseminate it directly to the judges from that office? And then locally, I don't know if we're planning a meeting with the new judges, but maybe even their attorney, like you meet with their attorney or whoever and say, we have this process. And so we can kind of make them aware of it, from the start, instead of just doing it at a sentencing or when there are a plea and there are 50 people in line to take a plea. So we could be, affirmatively move forward, be proactive about it instead of waiting until like a case comes up.
Well, that is a great point. I will tell you that the Office of Court Administration is not a judicial training entity. It's not the Texas Center for the Judiciary. It's not the Texas Municipal Courts Education Center. Those training entities are especially charged with training their judges. And I can guarantee you that at the lower court levels, at the justice court level and the municipal court level, they are being taught this. because I know the individuals who run those training programs and that this is the kind of thing they train their judges on to know. Now, the Texas Center for the Judiciary, I'm a little less familiar with. There's a lot of material for them to cover. This may not be on their radar as the most important thing, but to the extent that it's not, we need to try and educate them. I can also tell you that when I worked for the Office of Court Administration, one of my main jobs was being an interface with the district clerks and the county clerks. And so I spoke at their conferences all the time, and people from OCA continue to do that. And sometimes if you can educate the clerks that this is necessary, you have in effect educated the judges and gone a long way toward doing that.
Ted, any other questions, Ted?
Roger? Yes.
So I think I'm the only one who goes to misdemeanor court in this room, but when I've been going to county court at laws, they've been not doing exactly what this says, but almost always, because my clients are indigent, they will say, well, I'm ruling the court costs, making them run concurrent with the sentence, so they give them enough credit that they've zeroed out the court costs. From this, I think,
Without serving more time.
without serving more time, they don't add time on, especially if it's time served on bond. But reading this, it sounds like that may not have been proper to begin with, but it still ends up with the result of it.
Well, it still ends up with the result of them owing nothing, and that's a good thing. And there's something I forgot to say here, is that part of this bill, Senate Bill 1913, expanded what counts as community service. So now working to get your GED, taking certain kinds of classes, this is on the bench card, you can read it, taking certain kind of classes, even
Is that in all cases or just to satisfy the cost?
that's to satisfy the costs. If the judge says, yep, sir, ma'am, you cannot, I find that you cannot afford to pay this immediately, but I order you, in lieu of doing that, to perform community service. The bill also said that now you get credit of at least $100 for every hour of community service that you perform.
Every 8 hours.
I'm sorry, $100 for every 8 hours of community service that you perform. Okay? I think that's what it, yeah.
Excellent, Ted.
Yeah, each day served, right.
Does anyone else have any questions, Ted?
I do. It says that during or immediately after imposing a sentence, right?
Yes.
So on a deferred adjudication, a sentence is not being imposed, right?
Technically, that's correct, and technically, there's no conviction. But if you look at the court cost statutes, almost all of them, when they say, upon conviction, thou shalt pay X amount of dollars. There's another statute that says, for purposes of paying court costs, conviction means, and one of the things is deferred adjudication. So for all practical purposes, even though technically it's not a conviction, that's when these are being assessed, and that's the time to bring it up, right then.
We'll see them too. We'll see that the fines and court costs assessed in those situations.
Right.
More than when somebody's incarcerated.
Right. Okay, well, thank you very much.
All right, thank you, Ted.
Sure.